Welcome back to Winning Isn't Easy. You know, I read cases from courts across the United States because I think that I can learn many lessons from judges, how cases are handled, and what carriers do to deny claims. And I learn from those lessons and incorporate these lessons in the way I handle cases. Now, sometimes reading these cases can be like a mystery story because you're not quite sure how the ending is going to turn out until you read the last page. Sometimes they read like a fairy tale, and sometimes they read like a horror story. But before I tell you these stories, let me explain how Mutual of Omaha will determine the definition of occupation. Now, you need to get out that particular policy that you have because, as I've said, Mutual of Omaha has a lot of different versions of the policy. And we want to be specific to your policy. So now that you've got the policy out, let's talk about the story of Ms. Winooski. Now, Mutual of Omaha policies will insure your own occupation. The policy doesn't insure your job, and it insures your occupation at the time you become disabled. As I said, they have a variety of policies, and some of these policies will define occupation as how it's performed in the Dictionary of Occupational Titles. Others will define it as how it's performed in the national economy, while other Mutual of Omaha policies will define it as how it's performed for your specific employer. So obviously, you need to know the definition of your own occupation because that's what you're going to have to prove you're unable to do. Now, part of this involves giving the doctor an accurate history of your physical, cognitive, and social duties that you have to perform as part of your occupation. You want to give that history not only to Mutual of Omaha, but you want to give it to your doctor. The reason I say that is that the Mutual of Omaha is going to ultimately contact your employer and get their version of your occupational duties. And they just might not use that, or they might not use the one that you've prepared, or they may come up with yet a different definition of your occupation. But ultimately, Mutual of Omaha is going to be sending your doctor an attending physician statement form. Your doctor is going to be asked to identify what you can do physically, cognitively, and socially, and measure whether or not you're capable of doing your occupational duties. Now, sometimes, and more often than not, the APS form doesn't really give them any history about your occupational duties. It just asks the doctor about your functional capabilities. That's why I think it's important that your doctor understand from you and your perspective what your occupational duties are. So when the doctor's asked to answer this question, they can consider the answer in conjunction with or in view of the actual duties that you are to perform of your occupation. Now, I will tell you, one of the biggest fights with Mutual of Omaha is how they decide what your occupation was at the time you become disabled. And they'll often misclassify a policyholder's occupation. And that means one thing, a claims denial. So let me tell you about the case of Ms. Winooski. Now, interestingly enough, she had an IDI policy, so she was able to testify. This doesn't happen in an ERISA case. Now, she was a mechanical engineer who became disabled by a number of health conditions, including idiopathic gastroparesis. Her claim was denied because Mutual of Omaha concluded that her job duties were sedentary and that she could do sedentary work. Now, because there was a trial, she was able to testify in front of the judge. And the judge noted that the material duties of her occupation were intellectual and not physical. In other words, as an engineer, she was thinking, designing, drawing, plotting out things. She wasn't necessarily standing up, walking around, or on any type of floor or construction site. What happened in that case was that the judge took Mutual of Omaha to task for finding that under the own occupation standard, the medical evidence only addressed part of the equation. In other words, what she could do physically. The judge held that to assess her abilities to perform her own occupation, they have to be aware of and actually address the physical, cognitive, and social behavior requirements of the occupation. Now, that was a great result, but that only happened because she had the ability to testify to the judge. If this is an ERISA case, you, as I said, have to make sure that in your description of your occupational duties that you give to Mutual of Omaha, that you're accurate about those physical duties, those cognitive duties, and the social behavior aspects of your duties. Well, what do I mean, by the way, by social behavioral aspects? I'm sure that as a mechanical engineer, Ms. Winooski was interacting with co-workers, her supervisors, and maybe even a client. And so how her medical condition impact her ability to concentrate, how her pain may have interfered with her ability to be pleasant and engaging with her co-employees, her supervisor, or her client are obviously very important things. So the court wants to make sure that you have considered, and Mutual of Omaha has considered, the full range of your duties. If your claim has been denied, I suggest that as part of the claims denial appeal, that you submit an affidavit regarding your occupational duties, particularly if they have misconstrued your occupation or your occupational duties. Now, you're also probably going to have to get a vocational evaluator involved, and I'll talk about that in a minute. Now, another game that the Mutual of Omaha will play is when the definition of disability changes from own occupation to any occupation. The game is to find that you can perform sedentary work, and that's all it takes to justify claims denial, because the issue is there other work that you're capable of engaging in? In other words, is there another occupation that you can do the material and substantial duties of based on your education, training, and skills that you've learned at a wage such that Mutual of Omaha would not have to pay your benefits? So that's a lot to unpack. Mutual of Omaha has to look at your prior work history, your prior educational history, the duties that you've learned in your current occupation, and determine whether or not, through the use of a vocational evaluator, that you have what's called skills, transferable skills. So for example, as an engineer, if you've got certain skills, you might be able to take them to another occupation that uses, for example, spreadsheets. Or a better example might be a nurse. You know, you might not be able to be a surgical nurse, but you've got transferable skills that would let you be a peer review nurse, or just a nurse reviewing medical records, or a charting nurse. So the issue obviously is one of importance to make sure that we're talking about getting a vocational evaluation as part of any appeal. So let me tell you about the tale of Mr. Contreras. This is a Northern Illinois case, Contreras versus the United of Omaha. And in that case, the definition of any occupation included terms as follows: an occupation for which you're reasonably fitted by training, education, or experience, and can be expected to provide you with current earnings of at least 85% of the basic monthly earnings within 12 months of your return to work. Now, some courts will conclude that absent a time limit in the policy on when the target wage can be earned, transferable skills alone are going to be sufficient to justify termination of benefits. But that wasn't the case here, because Mr. Contreras lacked the job skills, training, or ability to perform the jobs that United of Omaha had identified in the transferable skills analysis, and he couldn't meet the wage requirements within 12 months. The way he was able to prove that was to hire a vocational evaluator to test him, to determine his skills, the transferability of his skills, and to take apart Mutual of Omaha's transferable skills analysis. The other thing that the vocational evaluator did was to do a labor market survey to determine what the availability of these jobs or occupations were that United of Omaha had found that allegedly he was capable of performing. And the vocational evaluator also, as part of that labor market survey, did a wage survey to determine what the wages were and whether it was even possible for him to meet at least 85% of his basic monthly earnings within 12 months of a return to work. I use vocational evaluation reports all the time in my appeals, and you can see in this case that having that vocational report could make all the difference in getting benefits. And certainly in my first example, would make all the difference if there was a fight about what in fact that person's, Ms. Winooski's, occupation was. So the lessons I learned, and I hope you learn from these two cases, is make sure that you explain your work history backwards. Well, what do I mean by that? You want to make sure that you're thinking about the physical, cognitive, and social behavioral duties that you have of your occupation, and write down them on a piece of paper in a column for each. Then I want you to think about why it is you can't do those specific duties. Because when you write your occupational duties, your work history form for the Mutual of Omaha, you want to make sure that all those things are covered. And of course, as I said, you want to make sure you give it to your doctor. And the second lesson is that you get a vocational evaluation report if your claim is denied based on a misclassification of your occupation or at the any occupation stage. Well, that's it for this episode. If you like this podcast, please like the page, leave a review, or share it with your friends and family. Remember, the podcast comes out weekly. Stay tuned next week for another insightful episode of Winning Isn't Easy.